Welcome to CC Partners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.
We have some time. We have some attendees, so we can certainly have our question and answer period. Looks like we have a couple of questions already. Please feel free to use the question and answer function at the bottom of your screen. And we're going to start going through some of these questions. Question number one, if a union is on my work site, am I allowed to ask them to leave? That's an excellent question. I'll appreciate some input from Jay and Brandon too, but the first thing I would want to do is go back to what we've touched on before, which is Section 77 of the Labor Relations Act. It says that no person has the right under the Act to be persuading workers to support a union during working hours. If those are the parameters of why a union is on the site or what they are doing on the site, my view is yes, you can ask them to leave, but the proper lawyer's answer is always it depends. So I'll turn it over to Jay and Brandon to give some input as well.
Well, that's right, Mike. It depends on what your collective agreement says, potentially, and on what, if you're a subcontractor, what your general contractor's collective agreement says. Most collective agreements in the construction industry will give the union reps access to site on notice. And so if the rep says, I want to come and I want to talk to the guys on notice, they typically can. Now, that's to talk about union representation. That's not to persuade the guys to be for or against a particular union during their working hours. So it's a very fine line, but the line I like to draw is fine. If you want to come and talk to the guys, you've got the right under the collective agreement, but I've got a right to expect them to be working and performing productively during their working hours. So if you want to come at break time, you want to come at lunchtime and they want to talk to you, that's fine. But beyond that, I would try and enforce the no persuasion during working hours. And it's always your right, if those rules are being violated, to bring unfair labor practice proceedings against the union at the labor board.
Yeah, and there's a couple of other things to that. A union on the work site, as any other visitor on the work site, will have to follow certain work site rules, particularly with health and safety. Chances are they have to check in at a gate before they get onto the site. Certainly they have to be wearing the proper PPE. And if they're distracting or disrupting workers from work, you're absolutely within your rights to manage your work site.
Yeah, and remember too, that the owners, as the property owner, control who is and who is not invited onto their property, and anyone who is not invited onto their property is potentially guilty of trespass. So if you've got a cooperative owner who doesn't want union representatives on their property for any reason, they're in a position to enforce that. It doesn't always occur, but sometimes owners just say, no, I don't want. And outside the gate's fine, but no one on my property who's not here at my invitation.
All right, we've got question number 2. Can I extend the timelines for a response? I appreciate the question, and I expect this means, can an employer get an extension on filing a response to a displacement application or a decertification application? The easy answer is don't count on it. Very hard to get an extension on a deadline at the labor board for filing a response in the absence of very compelling reasons that don't prejudice any other parties. That's my take on it. Jay or Brandon, do you have anything to add?
No, nothing to add, Mike. It's exceedingly rare that an extension is granted, and the circumstances have to be very compelling.
Nothing to add from my side either. Just, I mean, you can always ask for it, but I think your take on the likelihood is probably accurate.
Yeah, the labor board is very strict at even the most lenient times, and certainly when it comes to the open period, they enforce their rules quite strictly. Question number 3, can a foreman/supervisor initiate an application to terminate bargaining rights? I'll turn this one over to the panel.
Yeah, and I'll take that one, Mike, because it's another, it depends on what you mean by a foreman or a supervisor. The normal dividing line as to who is in the bargaining unit and who's outside of the bargaining unit is the working foreman versus general foreman distinction or non-working foreman. If you're talking about a supervisor or a non-working foreman, they're considered a member of management, and any initiation on their part or any undue influence or support will be seen as an action of management, as an action of the company, and will taint the application. So that they're out. Your working foreman, however, is in the bargaining unit. They're a classification under your collective agreement. You pay them that extra premium as the foreman. They're perfectly well entitled to have their say. So if they support keeping the existing union and they're resisting the raid, if they think the guys should move to another union and they're encouraging the guys to go to another union, or if they think that the union hasn't served the interest of the employees well and they want to encourage and initiate a termination application, that is perfectly within their rights to do so. The caveat to that being they can't be in the pocket of the employer or acting as the tool of the employer in initiating that application. Subject to any Mike and Brandon's comments, I think that covers it.
Yep, very well said, Jay. Again, very important to understand what the bargaining unit is, how it is described, and who is in the bargaining unit. And 4th question, what do I do if an employee will not stop asking my opinion about a raiding union? Brandon, why don't you give us your impressions of this first?
Yeah, so the first thing I'll always say is speak to a lawyer. Call your lawyer and ask them what you should do, but because it depends on the circumstance. But I would say most of the time you're gonna have to tell them that you can't provide them any assistance. Whether it's about a raid or whether it's about a decertification, you cannot provide the employee with assistance in that. So you're gonna have to tell them that, and you're gonna have to tell them that they're gonna have to make the decision on their own, or you can maybe direct them to somebody else who can answer their questions. You can, I believe, Mike and Jay talked earlier about directing them to a lawyer who can help them, but you can't give them help yourself, and your lawyer can't help them either.
So the one addition to that, I would say, is because we're talking about a situation where someone won't stop asking your opinion about a raiding union. If I've got a good relationship with my incumbent union and I don't want to see them go, I'd be encouraging that employee to talk to the business rep from the incumbent union about the raiding union.
So I'll make one more comment on that, and perhaps I'm a little bit jaded, but what I've seen recently is an increase in employees getting a little bit crafty, and my expectation is at the suggestion or possibly direction of their union, and trying to bait managers into tripping up and saying something that they ought not to be saying, and having a recording device on. That would be a bit of a red flag for me if I had an employee who was very persistent in asking me my opinion on labor relations and my opinion on whether there's a union to favor. That would raise a red flag for me, and I'd be quite cautious in my communications with that employee, even more so than usual. Again, based on what I've been seeing personally in some cases that I've had to litigate, where it's time to get ready to go to a hearing, and I start getting audio recordings sent to me, and union saying we're going to be relying on statements made in this recording. So, that would just make it even more important to keep your communications very careful during the open period. On that note, we really appreciate your questions. Thank you, everybody, for attending this webinar. If you have any further questions, you can certainly find us online. Our website is www.ccpartners.ca. You can also find us on Twitter and LinkedIn. If you want, you can subscribe to our weekly blog, The Employer's Edge. You can do that via our website. And again, you can reach out directly to any of our lawyers for employers, myself, Mike McClellan, Jay Ryder, Brandon Lowell. We're always happy to take your phone calls or answer your emails. And certainly we have the right people to assist you with any of your workplace legal needs. On that note, thank you again, everybody. Happy Open Period Eve. And we look forward to seeing you again at the next presentation of the Lawyers for Employers. Thank you for attending. Goodbye.